Go ahead, unpause. Come on in. Water's fine. See the wonderful young lady right in the and share my screen. Nice. Uh-oh. What's going on? I probably should either mute or pause this recording. I did pause it. I thought we was getting ready to get started again. All right, if we're ready, good morning to everyone and good morning to those who are watching by way of Zoom. Here in this new normal, we've gotten quite used to speaking to two audiences, both those who are present as well as those who are in attendance virtually. Although I can't see those who are attending virtually, it's certainly good to be with you. My name is Kenya Smith. I have the pleasure of serving as the Judge Freddie Pitcher Endowed Professor of Law here at Southern University Law Center. And I'm here I was asked to present on a topic that's near and dear to my heart, business entities. But in my research and in working in the community, I've run across some issues that I thought would become an excellent topic for advising lawyers and making sure that we as the bar are affiliated or are aware of, in case you ever run across those, whether it be a client or if you're like some of us, those family and friends that just have a quick question, right? That, we always like to say, well, I don't practice that kind of law. And they say, well, it's just a simple question. You're a lawyer, aren't you? And so this is just one more area that actually involves a cross section between successions law and business entities law, with a particular focus on corporations, if you will, and something what I think, at least for me, was a lesser known and not so often utilized area, and had particular implications and consequences. Let's see if I can. There we go. Let's get. So as you can see in the first slide, I like to start with what we have traditionally, we generally thought, although in the 21st century, we know that the definition of family is far-flung and has far different implications, definitions, and the like. But one thing that's certain, we all have those who are close to us, those who we would give an appendage for, often for their safety, for their security, particularly now at holiday times, as we're hoping to come out of COVID, those gatherings, getting with these people, and sometimes with those who we are in the household with, we hold dear. So why am I showing the picture of this family? Because as we go through this cycle that we call life, we often overlook the simple things until they are taken away from us. We now appreciate, again, holiday gatherings and the like, we're able to appreciate this thing we call family. Unfortunately, also a part of this life cycle is the end of life. When we lose a loved one, many of us experience that in varying degrees at varying times. It's certainly something, the old adage, there's two things certain. One is taxes, and we know what the other one is. We certainly must all go that way. But when we do, there's an attending grief that is always associated. We long for the loved one. We miss that loved one. We deal with all of the phases of grief and the like. Unfortunately, there's too often also another byproduct of the loss of that loved one. And often when I and my colleagues teach, we talk about losing Nana or Grandma or losing Pop, Big Dad, or the like. But too often there's also the unavoidable, or I would say avoidable, but too often the fight over money. And that happens in varying degrees. We fight over material things, the things that at one point we said we never valued, we never wanted. I never thought about that table. I never thought about that car, that bike. Nothing that I wanted there until that loved one closes his or her eyes, and now all of a sudden, it is the most valuable thing on earth. And we see that in lots of different areas. Those of you who are in estate planning, those of you who have a trial practice, those of you who are in different areas of law, we see it all the time in our personal and in our professional lives. And in the business community, it's really no different. Let's see if I can get this bar down a little bit. It's really no different in that context. In fact, I could go ahead and minimize this. Get this out of our way as well. It's really no different in the business world. And we often then find ourselves having discussions with lawyers and lay people who fashion themselves lawyers. We've all, like a lot of us, we now get a lot of our medical advice from Google or on the internet. We have a lot of people who are self-made lawyers. They've gone online to Rocket Lawyer. They've gone online to a lot of different sources, and so now they are ready-made lawyers. If the case might be, people might come into your office. If you were like me in my former life, let's see, can I minimize this? Or do I have to keep these controls up? Well, we didn't have the screen up last time, right? Well, that's okay. It's not okay. All right. Just annoying me here. We'll work through it. But at any rate, there are a couple of, I'll move it out of the way so we can see some of these. Someone may come into your office and say, I need to incorporate. And those of us who are recovering corporate lawyers or recovering business lawyers will attest. We know that they don't necessarily mean I need to incorporate. We know they're looking to organize their business and they need your help for that. Now I know for many of us, this business entities, corporations, and the like was the subject that we loved most, right? It was the subject that we couldn't wait to get up at 9 a.m. to talk about. It was the one we looked forward to. It was the meaty and the sexy topic. So I won't belabor and bore you with all of the intricate details of the distinctions between the two. But there are a couple of things that I think we need to set as a predicate for the discussion that we're going to have. And I pointed to a couple of our general business entities, our basic business entity formations that are important to keep in mind. We have the corporation that is a hallmark, is a staple of the American business community. It has certain characteristics that we'll discuss in just a moment. Separate identity, the corporation, corpus, Latin meaning body. It's a separate person. It is a separate juridical entity, if you will. It is a person on its own, the same way we are separate people, even though we might have siblings, the same way we are separate people, even though we have parents and the like. So it's a separate person, has its own tax identity, its own liability. It provides protection, corresponding protection for its owners and the like. And it's a primary reason why corporations are often set up to provide that liability protection, because that corporation then shields those owners from that. Now, coming along with that, and I certainly, again, won't bore you all with a tax primer on that. And certainly there are those that I know that would know this stuff even more than me, that what comes along with it, because it's a separate person, just like we pay our own taxes separate from our family members, separate from our friends. The corporation pays its own taxation, so that brings with it the double taxation problem, as you will. And there are frameworks, there are rubrics that work around that, but that is something, again, for a broader conversation for another day. There's also formalities that are very important that we will return to, as the case might be, that come along with forming a corporation. You have to have certain things in place, otherwise you risk the protections that come along with having a corporation. The corporation came about in order to remediate some of the issues that were present with what we traditionally know as partnerships and sole proprietorships. And I put those in one bucket, one category, because they have one distinguishing feature between the two. A sole proprietorship is a single owner entity, that when that person has not chosen or not elected to incorporate or to form their business any other way. So if I just go into business, Smith's grocery stand, I will be deemed a sole proprietorship. What comes along with that? Well, I don't have the double taxation problem, because it's just one. It's me and the entity. We are one and the same. It's flexible because I have that. I don't have to have a one-person meeting. If I want to do something, I don't have anybody else to ask. Now, if I had trouble making up my mind and I was having too long a conversation with just me, that's a whole different conversation. That's a different area of law that we don't have time for today. But the decision is just me. So a sole proprietorship has certain benefits, but it also has risks that are associated with it, that there is no such thing as a corporate shield. There's no shielding me from personal liability. So if someone gets injured by a piece of fruit that I've sold, or something that my employees have sold, they can come after my personal assets, my home, my car, and the like. Similarly, a partnership is distinguishable from a sole proprietorship in that it's two or more people involved in business without electing to form as another business. So if you don't form as a corporation, you don't form as an LLC, you don't form in a particular way, you will be deemed, if it's one person, a sole proprietorship under the law. You'll be deemed, if it's two or more, a partnership. And of course, that is a key distinction for liability purposes, as well as tax and other financial reasons. Well, as we matriculated along in the 70s and 80s, again, I'll spare you all some of the intricate detail. Another entity was developed called the LLC, or the limited liability company, marrying the best features of both the corporation and the sole proprietorship, keeping the entity level shield, the corporate shield, if you will, that came along with the corporation, while allowing you flexibility in management, not having to go through a lot of the corporate formalities, being able to manage a business a lot more like a partnership or a sole proprietorship, as well as taking advantage of some of the tax benefits. And again, this won't be a lecture on the LLC, but it is something that I want to make sure that we pay attention to. There's another entity that's there called the closely held or the closed corporation, and some of us may have heard of the term, may have even had clients try to use the term. Well, we're a closely held corporation. We're a closed corporation. Well, technically, under Louisiana law, that's not a thing. There is no statute on the books. There is no code article or revised statute section that you can point to that separates a closely held or closed corporation from a corporation in general. Now, why is that important? For reasons that we'll discuss in just a moment. That becomes a misnomer. People think that there is a key distinction between a closely held and a general corporation in terms of how they're run, because people sometimes mistake that a closely held corporation can be run more like a partnership or can be run more like an LLC, when there's nothing under law, there's no statute on the books that technically allows you to do that. And I want to make sure that we keep that in mind for reasons that I will share in just a moment. Now, going back to our corporate form, and what I'll do is I'll focus primarily on the corporation for purposes of the rest of this conversation or this discussion, for comparative purposes and for simplicity. A corporation is a business that has filed technically what we call articles of incorporation in Louisiana and other states. It may be called a certificate of incorporation. Generally, it's referred to as the charter of that business, and it is, I call it like a birth certificate. It is proof that the corporation is now in existence. The owners of that corporation are called shareholders or stockholders. They own what are representative shares that represents their ownership interests. It's called other things in other entities. So if you're in a partnership, you have a partnership interest. If you're in an LLC, you have a membership interest. But in a corporation, you will have shares and you will be called a shareholder. You'll be governed by the state's corporate statutes. And so there are things, there are what we call mandatory rules, the thou shalt, the things that you must do. And then there are the permissive rules, those things that if you don't decide for yourself, as we will discuss in successions law, here's what the law provides in case you are silent, in case your articles of incorporation, or as the case might be, your bylaws are silent. Another very important feature of it, management is centralized. A corporation is what we call a centralized model. Management authority is vested in a board of directors who are elected by the shareholders. And I'll come back to that in just a moment. What the shareholders get in exchange for giving up that direct control, that direct management of the affairs of the corporation, is you get a full liability shield. Now that is an older and more traditional model. As we said, the LLC was designed to address some of the clunkiness, some of the formalities, some of the rigidity associated with that. But that is a fundamental feature of the corporation. And so, just so that everybody thinks that I'm just pulling this out of the air, we can refer to Louisiana Revised Statute. I won't read the statutes to you. I remember when professors and presenters used to do that to me. I hated that, so I won't do it to you all. I'll just refer you to Revised Statute section 12-1801, which says that every corporation, I feel like my old dad, who was a minister, he talked about all people. It says that each corporation, if they're required, must have a board of directors. There's no exception to that rule. And it says in subsection B, all corporate powers are exercised by or under the authority of the board of directors. It does not give an exception. It does not say unless. It doesn't give you any. It doesn't give us any of that language that our professors used to tell us would allow an escape hatch in that particular vein. That is important for a particular reason. The officers and the officers. So the corporate structure is built in three levels. The shareholders, as we said, are the owners of the company, of the corporation, but they don't directly manage. They delegate that authority to the directors. And I thought I'd just emphasize that a little bit for us, the directors, who then can appoint officers and the like. And why is all of that important? I've thrown a lot at you, and I think this is a good point at which I should share a bit of a story, particularly how some of this came across my desk. As I mentioned earlier, you'll often get a call. Someone, client or a friend or someone will call and say, "Hey, I have a problem." They say, "Okay, how can I help you?" And they'll say, "Well, my business partner has passed away." You say, "Oh, wow, I'm sorry to hear that. I'm sorry for your loss." And then we always ask that question that we hope we never regret. Let me know if there's anything that I can do to help. Famous last words, right? So then they say, funny you should ask. Where we're in the process of trying to settle the affairs, we're in the process of trying to help the family along. Notice I use the words business partner. So then you start to dig in and you realize that what they have is a corporation. So you realize that they didn't really understand what they were saying when they said business partners. They really weren't partners. They really were fellow shareholders of a corporation. And as I mentioned, with that corporation comes certain formalities. So any good lawyer who's helping, whether free or otherwise, because we know from our ethics and professional rules that once you agree to help someone, you're bound by all of those rules. You have to make sure that you're educating them and making sure you're empowering them in ways that truly help them. So you start asking them to give you their corporate documents, get you the charter, get you the bylaws, get you the stock certificates, get you the corporate minute books and the like, to which they naturally then give you that glazed over look and that universal response, huh? Oh, I'm not the only one who's had that conversation, right? So then they start going through that, and you realize that they may have not operated exactly like corporate law in conformity with what corporate law requires. But now, everything's fine. Everything's fun and games until it's not anymore. So to make matters even more interesting, how many folks? I know I can't see. I'm gonna presume that you're responding. How many folks have children? All right. Yeah, yeah. How many folks have been children? All right, that should cover everybody. All right, so we either we have children or we've been children, so we know the parent-child dynamic, we know the sibling dynamic, and as I said before, we know what happens when someone closes their eyes. That the children, the heirs, often come in, and I like to use, and y'all forgive me, I'm not as young as I look. I like the old Sanford and Son adage where Blind Mello Jr. comes in and says, "I want my daddy's records." So the son or daughter comes in for purposes of our discussion. I'll call him Sonny. Comes in and says, "I'm here to help run the company. I'm here now." Sonny has never participated in the company throughout his particularly his adult life. Dad has tried to get him involved, tried to get him interested. Never. It was off doing his thing. But now I'm coming back to run. I'm coming back to help run the company. Well, the other partners, or we'll call them the existing board of directors, the other shareholders, are saying, "Wait, hold up. We've been running this company. We've been toiling in these fields for X years, and now you want to come back and get your share or help run the company, bring all of your new ideas and the like." And so we all can relate to the natural tension that's there, and the discussion that needs to be had between the directors and the son, because a lot of these kids have watched too much General Hospital and Young and the Restless, and so they think they're Jack Abbott or Victor Newman's kids. And I've come in. I'm coming. I want my dad's seat. I want my dad's seat as president. I want my dad's seat on the board. And you have to then explain, well, that's not exactly the way that works. You may inherit your parents' ownership stake in the corporation, but you don't inherit a board seat. You don't inherit a position. You don't inherit a presidency. You don't inherit those things. You own shares, and those shareholders then elect the directors who then appoint the officers. So that discussion sometimes goes over well, other times doesn't go over quite so well. And so then in that, people then start getting their own lawyers, researching for themselves, and the like. And so, like was the case in many instances, Sonny then says, "Well, I don't like the way you all are running. You've been running Dad's business." So then the conversation evolves to, how do we resolve that particular difficulty? Well, corporate law has a solution for that. If a shareholder does not appreciate the way the board of directors are running the company, then you can bring what's called a derivative lawsuit. But in order to do that, and we'll define that in just a moment, but in order to bring a derivative lawsuit, I know we all remember this from business entities law because it was our favorite subject. We all remember the demand requirement, and Louisiana doesn't have exactly the futility doctrine, but it does have a form of that by saying that waiting would cause irreparable injury to the corporation. Again, I promised you all I wouldn't read the statutes to you, but just remember that there's a written demand. So if I don't like the way, if as a shareholder, whether I've inherited my shares or I've bought into it, if I don't like the way the corporation is being run, I make demand of the board. You need to do things differently. You need to do it my way, and then wait 90 days before bringing a derivative lawsuit. Well, a lot of people want to work around that and say, well, it's not a derivative lawsuit, it's a direct lawsuit. I certainly won't bore you all with the distinctions there, but generally they are both covered by the definition of a derivative lawsuit, meaning quite simply that you, the shareholder, are attempting to now step in the rights and exercise the rights of the corporation. Now, domestic corporation just means a corporation incorporated in that particular state. A Louisiana corporation would be domestic in Louisiana. A Mississippi corporation would be foreign. But whether you're exercising domestic or foreign corporations right, it is the shareholder asking the court to allow him or her to step in and protect the corporation. Go back to Sonny. Sonny is now saying, I need to protect my daddy's legacy. I need to protect the corporation because these ne'er-do-wells who are running the corporation are not doing it right. They're running it into the ground or the like. Well, Sonny doesn't necessarily like this demand requirement, right? This takes too long. I want to get around that. So Sonny comes up with, Sonny says, wait, hold up. Wait a minute. We've got a little variation here that on law that we can come up with, because Sonny is now again he's come home to protect Dad's legacy. He's come home to care for. He's come home to do all of those things that an heir would do, that a succession representative would do on behalf of their loved one who has now passed on. And again, I won't bore you with all of the details, but here enters succession law. And so we know that that a succession representative, whether it be an administrator or administratrix, if it's a lady, an executor or executrix, if there's a will, and the person receiving that appointment would be a lady, would be an executrix, would be the party generally responsible for the managing the affairs of the decedent. And Louisiana Code of Civil Procedure, Articles 3094 and 3096 give us the processes for being appointed, the inventory. If I apply for appointment and no one asks for notice and no one's going to challenge that, then no harm, no foul. It's a pretty smooth and easy process. If there is opposition, if there are notice requirements, then the court will have a hearing, and after that hearing, if I'm found to be duly qualified, then I would be appointed the administrator. So now Sonny has gotten himself appointed as the administrator of Dad's estate, because Dad died intestate, just like those of us who run our corporation in a less formal way. We often don't take care of our affairs. And a lot of us, even those of us, we like to think that this is a lesson for other people. But the reason why I think this is important, because sometimes we as lawyers can be the doctor that smokes. We got good advice for everybody else, but we haven't written our own will. We've got our law firm, and we aren't following our corporate formalities. And so when we get into it, like my dad used to say, we could say amen or we could say ouch. Sometimes I got to say ouch myself. But when we don't follow those formalities, whether it's a professional corporation, our own law firm and the like, when we don't follow those formalities, we could find ourselves in these various situations, or have our children, our heirs, our loved ones in these very situations. So Sonny has now had himself appointed as the succession representative, as the administrator of Dad's estate. And so now he and his crafty lawyers come up with a workaround, because they don't want to have this long protracted fight with the directors, because we know corporate law is basically schemed for the directors to have home field advantage. The directors are supposed to run the corporation and the like. So the administrator finds a lesser known, in my opinion, provision in law, Louisiana Code of Civil Procedure, Article 3224, that says that when it is deemed in the best interest of the succession, and after compliance with certain provisions, the court may authorize a succession representative to continue any business of the deceased. Now, if you go back and look at this article, it does not distinguish between partnerships, sole proprietorships, corporations, LLCs, or the like. It says any business. So it is a provision where the court, who having jurisdiction over the succession, can authorize the succession representative to run the business. Aha! So Sonny's found a way to petition the court to let me run the business and move these directors out of the way. Well, there was another twist, another angle that I glossed over just a bit. I want to come back to that in this particular instance, and may be the case in some instances, less so in others, that the dad died living in one parish, and the business was domiciled in another parish. So under corporate law, there's also a venue provision that says that if you're going to have a fight over who's going to run the corporation, how we're going to run the corporation and the like. The venue is the parish in which the corporation is domiciled. So now Sonny has filed for a succession, let's just say in a parish more favorable to, in his opinion, to his position. And so now the directors find themselves wanting to pull this fight from that parish into a parish where they would deem it more favorable. So now the court where Sonny wants to be has been petitioned to authorize him to continue Dad's business, to honor Dad's legacy, to get away from this, to get away from the way that this board is running the business. And the board is saying, no, not only are we in the wrong parish, but you can't do this under corporate law. You can't inherit Dad's seat. You can't become president through succession, through intestacy, through a will or otherwise. You can get his shares, but then we would have to vote those shares, and if you want to elect a board and the like. And so they said, no, we're not doing that. It says I can run any business with permission of the court. It also goes on, if we look at Article 3224.1, it also goes on to reference a corporation or a partnership that is a succession representative in an estate. If I show that I'm owning a majority interest, then the succession representative provided some notice to the heirs and the like, I can alienate, encumber, dispose of property and the like. And we know, those of us who hug the corporate tree, said this is antithetical to how corporate law is organized. You can dispose of those shares, but you can't just step in. Corporate law doesn't allow that. You can't just step in and start running the company. And so there becomes a fight and a balance between the two, between what corporate law provides under 1-801, setting up the board of directors, the demand requirements under 12:1-742, and even the venue requirements under 12:1-742.3, saying that if we're going to have this fight, we need to have it in the parish where the corporation is domiciled and the like. On the other side, we have successions law with the court, where Sonny and his co-heirs his fellow heirs are saying, well, no, we have the right to administer, to run the business. We have to do this because it's for the benefit of the succession. We're doing this to preserve the assets for the succession. And the way you all are running the business, it's not preserving those assets for the succession. So then the fight, that is brought in the court where the succession has been filed. And guess what? The court agrees to hold the hearing over whether to grant that, and the directors file opposition. They file an opposition to that, and they also file exceptions. File exceptions of no cause of action. They file exceptions of prematurity. They file a number of exceptions and the like, all of which are denied. Now I'm going to spare you all some of the intricate detail of that, but there are a couple of issues that come into play with respect to this particular fight. The petition to be appointed, to get the authority to continue the business on behalf of the succession, is considered a summary proceeding, and so it provides the speed and efficiency with which successions are designed to have. We don't want to have long, drawn-out successions and the like, whereas corporate fights are ordinary proceedings. So that may or may not be advantageous to one side or the other. You may find that your client or the persons who come to you for help may be the directors, or they may be the heirs. So the summary nature of that proceeding versus the ordinary proceeding were important. Why was that important? Because again, as the heirs wanted to wrap all of this into one hearing to get through as quickly as possible, to be able to, in some degrees, conflate certain issues. The directors wanted to have the exceptions heard, because they believed that, number one, because we're in the wrong venue, that just on corporate law, you should be kicked out of that parish and you should have to refile in the appropriate parish. But if we're in a summary proceeding, the court now can wrap all of those issues into one hearing and cause a whole lot more consternation, a whole lot more difficulty if you're going to take them up on writs, or even if you're going to take them up on appeal. So the efficiencies that are afforded in a summary proceeding versus the natural length and procedural components that are built into an ordinary proceedings are things to consider, because again, the succession laws are built to facilitate summary proceedings, whereas corporate law lends itself more naturally to the ordinary proceedings. So now that the court has made its ruling, has heard those exceptions, has denied those exceptions, has now ruled in ways that the board of directors thought were not appropriate under law, they say, well, certainly we can take them up on appeal, and certainly those in the audience and those watching on Zoom would know even better than a washed up corporate lawyer like myself, the distinction between taking a supervisory writ versus having to file a final appealable decision, both from a monetary standpoint in terms of the posting of bonds and the like, from a time element in terms of the speed with which writs are processed versus the appellate decision, and the distinction between a suspensive appeal, where if the court won't on its own volition, won't stay its order and allows Sonny to now step in and start running the corporation. And so now you have a decision to make if you're the board. Do I violate the court's order because I believe it's not righteous and risk contempt? Or do I file a suspensive appeal and have to post a bond trying to stop this or the like? Or do I file a devolutive appeal? Now Sonny has taken control of the corporation and has access to the bank accounts, the assets and the like that used to be under the guise of under the supervision of the board of directors, while the board of directors now, in all of their righteousness, are now on the outside looking in and now have to litigate from their particular perspective. Yes, sir. Right. That bond becomes cost prohibitive, right? And from a time standpoint, you want to do that. It would be even better if you could have taken them up on writs, right? Which is what the board did. They tried to take them up. They tried to take it up on writs, and the appellate court had a very, very interesting decision. I'll send Ms. Gilbert, if you don't mind, I'll send that decision, the citation for that decision. I don't have it handy. Where the supervisory, the Court of Appeals held this summary proceeding, this decision, because remember, what was the relief being asked? To allow me to continue the business. So you would naturally say, if what the court is allowing me to do is to continue the business, this is an ongoing matter. We're not closing the estate. We're not doing anything else. So this is ripe for a supervisory writ. No, the court said that the appellate court said that is a final appealable decision. So we're going to send it back down and order the trial court to allow the board of directors to file an appeal if they so choose. And so we're gonna do you a favor. We're gonna allow you to appeal it. We're gonna deny your writ, but we're gonna to allow you to file an appeal. What comes along with that? That hard conversation about legal rights versus business decisions. Because at some point, no matter how righteous a client's position, no matter how much they believe in their cause, no matter how much a particular person thinks that they've been wronged or the like, it's that old story that old joke that my torts professor, when I was in law school, told me. I remember I was in torts, and those of you like me were like me. We go to law school because we believe in justice, because we believe in equity, because we believe in the underdog, the person who is the downtrodden and the like. And so I'm reading a particular case and I'm offended by the outcome of that case. And so I'm railing against that, because that's what we went to law school to do, right? We like to argue, so we said we'd be good lawyers. So I'm railing against that. And my professor deadpanned me, and he said, "Mr. Smith, how much justice can you afford?" And I never forgot that. I never forgot that life lesson, because one of the hard conversations having with a client sometimes is, or even internally, is, how far am I willing to pursue this matter? How far am I willing to pursue this case? Can I afford to get to set this precedent? That's why we have institutional players who would seem like a small matter, they will take it to the Supreme Court, because it's about setting the precedent and the like, and they can afford to do so, and the like. But one of those conversations that, oh, we have a question. Okay, I'm gonna make this one point, and then I'll yield to that. You have that conversation between those board of directors. How far do you want to push this? Because we know, if we go back, when you all were operating this corporation, we have a doctrine in contracts and in other areas of law, in pari delicto. Nobody's here with clean hands, right? Sure, Dad, who's passed on, who can't speak for himself, he was president of the corporation, but a lot of the paperwork that was supposed to be in place wasn't there. And once we get into litigation, people can always make stuff look a particular way. And so with your version, with your recollection of what the deal was, doesn't necessarily bear out how far are we going to push this, when you may end up needing to walk away. And so the directors ended up making a business decision in that instance to move on with life, and say, you know what, you want the company, because in this particular instance, there was one of those companies, one of those corporations that really was labor intensive. The company was those people. It'd be like us with our law firms, right? Once you walk away from your law firm, somebody else says, okay, I'm gonna take over your law firm. Okay, great. You don't have me. And so those directors decided to make a business decision that they would move on with life, that they would they would start another corporation, but with what I like to call good advice. They decided to form an LLC this time. They decided to get more flexibility in management, to get around some of those corporate formalities, to get around some of those issues that were there. And they also decided to engage in their own estate planning, to then be able to have buy-sell agreements where they would have the type of succession planning that would avoid that particular collision of worlds. And for those who are watching and those who are viewing, I borrowed from, we've all heard of caveat emptor or caveat venditor. Well, I call this caveat advocatus. Let the advocate beware, because that collision of worlds between corporate law and succession law can sometimes provide unintended consequences and bends in the road that we haven't necessarily been taught to look for, in ways that sometimes can create unintended consequences. So with that, I appreciate your time, and I'll open it up to, I know we have at least questions and other questions that might be there. We hear? Is he still there? While we're doing that, I've got a couple of things in the chat. Okay, I don't think I need to address the LOLs. Best to have a will. Well, I'll address Mr. Richard's point. The will is one solution, but it's not. It doesn't. That would not have solved this problem. One, because that would change. They would have changed Sonny from an administrator to an executor, but it wouldn't resolve the corporate fight internally that has to be resolved through having your corporate books in order, having appropriate stock certificates, having it clearly outlined how the corporation is going to be run from a charter or articles of incorporation and bylaw standpoint. So that and also having buy-sell agreements. That is something that that in my former life I always used to recommend. In fact, when my past life, I worked for a security company that we all know they do some security for Southern from time to time. And one of the partners in the business died, but I had advised them to do a buy-sell agreement because a lot of times you'll say, I didn't go into business with your wife or your husband. I didn't go into business with your children. So I don't want even them as fellow owners of the company is not something I want to deal with because maybe they don't want to sell. The business that they never came to, never worked in, all of a sudden becomes so precious that they now don't want to sell or don't want to sell at the particular price point. So if you have the buy sell agreements, which is basically just a contract or a conventional obligation, then you would then have a automatic trigger that when if someone is deceased, you would set a price, and then the surviving business owners would buy out the estate of the deceased business owner, as the case might be. So those are things that need to be worked out internally under business entities law, whether it's under corporate law, if you're in a corporation, or even under an LLC partnership or the like. Those buy-sell agreements are something that we want to make sure that you keep in place. The LLC, so long the LLC is community property, can an operating agreement stop the wife from taking the deceased spouse's share? So it's very interesting. What is the mechanism? So so I'll back up just a second, and you have to forgive me. I'm one of those nerds that get excited about this kind of stuff, right? That the LLC was presented as sort of the best of both worlds because it presents advantages of a partnership while also giving you the protections of a corporation. So one of the things about a corporation, shareholder the ownership interests are freely transferable. They go through successions. They can be alienated by sale and the like. And there's usually, outside of that buy-sell agreement or shareholder agreements, there's very little you can do to restrict that. But one of the things that LLC law does is it borrows from the partnership law in the what we call the pick your partner principle. That, and again, when we are partners, there's something considered under law more intimate and more innate about that. So that when one partner dies, the other partners aren't the spouse or the heirs, the children or the like aren't automatically partners. They get what's called a naked interest. There's a whole lot of stuff around that. There's a whole lot of law around that. But the partners have a right. You don't get management rights, is the short version in a partnership. The LLC generally borrows from that, but there are caveats to that. If you're not organized for a term, that's why in LLC articles of organization, we will often organize your LLC and say this LLC will terminate in 2078, and we put it out far enough so that by the time 2078 comes, the world has changed 3 or 4 more times. But we put a date certain so that we protect against that we protect against the alienation or the passing of those interests in a way that creates management. Because it's really, at the end of the day, not as much about whether or not they own, but whether or not they can participate in management. And that's what the corporate structure generally denies, but the partnership structure gives. But that's why the pick your partner principle is there to protect. And that's what the LLC borrows from. The best way to deal with that is, again, in the operating agreement, you can put those buy-sell provisions in your operating agreement saying if one of the members is deceased, the same things we put into place, that we set a price for the membership interests and we would buy that person out and the like. So that's a way of dealing with that. There are a couple of ways of dealing with that. One, I used to always advise clients, set your LLC like your partnership for a term. That way you keep it from being as easily alienated, but also put those buy-sell provisions. But again, remember, those are things that need to be taken care of within the entity, because successions law doesn't care about it. And that's where we want to avoid some of the conflation that may cause other particular issues. I think I may have covered everybody in the chat. Did we still have a couple hands? Put his hand up and all right. well, well, I try to honor what I learned, what I try to learn early in life. So I'll close with this. My dad was before he was a minister, he was one of those teachers, and he used to talk about the three R's: the reading, writing, and how we got to arithmetic. Vice, how we got arithmetic. That R I will never understand, but they say we got to master those three R's. But my dad used to he said he had two adages. One was, he said, about the three R's, but he said, I always try to appreciate the five B's. And so I never understood. I said, I know the BBB, Better Business Bureau, all of those. I said, but the five B's, Dad? He said, yeah, be brief, brother, be brief. So with that, I always try to honor his second is stand up to be his other adage, stand up to be recognized, speak up to be heard, and shut up to be appreciated. So with that, I do appreciate you all's time and consideration. And again, I'm happy to share any additional information should anyone so desire. All right. Thank you so much.